Business law pledge. Definition: pledge is an accessory and real contract whereby a movable property which is capable of possession is delivered by one person to another to secure a principal obligation with the understanding that when the obligation is fulfilled, the thing shall be returned together with all its fruits and accessions. Characteristics of pledge. The contract of pledge has following characteristics. It is a real contract. The object of pledge must be delivered to a pledgee. Without delivery of the thing pledged to the pledgee, the contract of pledge is void. It is an accessory contract. The existence of pledge requires the existence of valid principal obligation. If the principal obligation is void, pledge is also void. But if the pledge is void, the principal obligation remains valid. It is a subsidiary contract. Pledge will be effective and enforceable only if the principal obligation has not been paid off at maturity. Thus, if the principal obligation is not paid, the thing pledged shall be foreclosed. Pactum commissorium is also applicable in this contract. It is unilateral contract. In pledge, the creditor pledgee has the obligation to return the thing pledged once the principal obligations has been paid. It is indivisible. The contract of pledge is not extinguished by partial payment of the principal obligation. Parties to the contract of pledge. Creditor pledgee is a person who receives the thing as a security of an obligation. Debtor pledger is a person who delivers the thing to the pledgee to secure the performance of his obligation. Subject matter of pledge. The object of pledge must be movable property within the commerce of man and capable of possession. Negotiable instruments, documents of title, and other documents evidencing titles to intangible rights may be object of pledge. Form of the contract. As between the parties, the contract of pledge may be oral or written, but there must always be delivery of the thing pledged. Otherwise, the contract is void. To be valid and effective as regards third persons, pledge must be in public state instrument, containing the description of the object and date of the pledge aside from its delivery to the pledgee. Kinds of pledge. Pledge may be voluntary or legal. Voluntary pledge is one which has been agreed upon by the parties. Legal pledge or pledge by operation of law is one created by implication of law, independent of the will of the parties, such as the retention of the property by a possessor in good faith for necessary and useful expenses. The retention by an agent of the property entrusted to him for the reimbursement of advances made by him or for damages caused to him by the agency. The retention of the thing by person who has executed work thereon till he is paid for his services, mechanics lien. The retention by the depository of the thing deposited for expenses and deposit fee. Obligations of the pledgee. To take care of the thing pledged. To return the thing pledged when the obligation is paid. If a thing pledged is found in possession of the pledgor or its owner, the pledgee is presumed condoned or remitted. Rights of the pledgee. The pledgee has the following rights to it: to retain the possession of the thing pledged until the debt is paid, to be reimbursed the expenses for preservation of the thing pledged, to compensate interest, fruits, income, or the dividends earned by the thing pledged with what is owing to him. For example, a promissory note for 10,000 was pledged by D to C to secure his loan in the amount of 10,000. On a maturity date, C received the amount of the note from the maker. C can compensate the amount he received with D's obligation. To bring action pertaining to the owner of the thing, to recover or defend it against third persons. To continue to have possessory lien on the thing pledge, even if it has been sold or alienated to a third person. The pledger, owner of the thing pledge, may sell it to another with the consent of the pledgee, but the latter shall continue to possess the thing pledge. To sell the thing pledge before maturity of the obligation. The pledge has the right to sell the thing pledge before the maturity of the obligation if there is a danger of destruction or diminution of its value. In this case, the pledgee must advise the pledger about it without delay, to give the pledger the opportunity to give the substitute of some kind of quality, same kind and quality. If sold, the proceeds shall continue to be in the possession of the pledgee. To demand immediate payment of the obligation or substitution of the thing pledged in case of fraud as regards to substance or quality of the thing pledged. To collect and receive the amount due for the obligation. And to have preference of credit. The pledgee has the preference of credit insofar as the thing pledged is concerned, subject to the preferential right of the government for the tax due on a thing pledged. Obligations of the pledger. The following is the pledger's obligation: to inform the pledgee of the loss of the thing if known to him. Otherwise, he shall be liable for damages it might have caused to the pledgee. To pay the principal obligation and its interest, if any. To reimburse the expenses incurred by pledgee for the preservation of the thing pledged. Rights of the pledger. The pledger has the following rights to wit: to ask the thing pledged by judicially deposit in the following cases. If the pledgee uses the thing without authority. If the pledgee, though authorized, misuse the thing pledged, and if the thing pledged is in danger of being lost or impaired due to the negligence or willful act of the pledgee, to participate in the public bidding of the thing pledged, and to have preference at the sale if his bid is equal to the highest bidder. Talaga. Requisites of the sale and the thing pledged. The debt must be due. Notice must be given to the pledger stating the amount due and date of public bidding. There must be a public bidding, and there must be intervention of a notary public. Note: a stipulation fixing the amount of which the thing pledge or mortgage should be sold in case of non-payment of principal obligation is void. Such stipulated price is called tipo or upset price. To replace the thing pledged with another of the same kind and quality in case there are reasonable grounds to fear its destruction or impairment. To demand for the return of the thing pledged if its accessions and accessories upon payment of the principal obligation, interest, and expenses, if any. Extinguishment of pledge. The contract of pledge is extinguished by payment of the principal obligation and other expenses. If the principal obligation and other expenses have been paid, the pledge is extinguished. Failure to pay the obligation gives the pledgee the right to sell the thing pledged at public auction. The sale of the thing pledged extinguishes the pledger's obligation. If the thing pledged is sold for less than the amount of obligation, the pledger is no longer liable for the deficiency. Any stipulation to the contrary is void. The pledgee is entitled to the excess if the thing pledged has been sold for more than the amount of obligation, unless it has been stipulated that the excess shall be given to the pledger. This rule is not applicable to pledge by operation of law, legal pledge, which requires for the return of the excess to legal pledger inasmuch as pledge is not voluntary. By the destruction or loss of the thing pledged, extinguishment by return of the thing pledged, by renunciation of the thing pledge, by payment of the principal obligation by any third person who has the right to thing pledge, and by other causes terminating ordinary obligation. Common characteristics of pledge and mortgages. The following are common characteristics of pledge, real mortgage, and chattel mortgage. They are accessory contracts